Former Minnesota police officer Kim Potter is expected to take the stand today during her own high-profile trial. She's accused of shooting and killing Daunte Wright during a traffic stop in April. Potter's attorneys are trying to persuade jurors to acquit her of manslaughter charges. They claim that the shooting was an accident in which the veteran police officer mistook her gun for a taser. Criminal defense attorney and legal analyst Joe Tamburino has been closely following this trial, and he joins us now to discuss Potter's anticipated testimony. Thank you so much for joining us this morning. I think a lot of people are going to be surprised that she's taking the stand in her own defense, because we've always been told when there's a homicide, it's a risky endeavor to have the accused take the stand. And especially there's so much video of her kind of talking about how she's feeling in the moment about what happened. So what can we expect to hear from Potter on the stand today?
Good morning. And you're quite right that it is always risky to have the defendant take the stand. But in a case like this, she has to take the stand. Absolutely. She has to get in front of the jury and tell the jury that it was an accident and that she never meant to use the gun. She wanted to use the taser. Basically, she told her brain, grab the taser, but instead she grabbed the gun. And she'll talk about all of that when she takes the stand. Because in a criminal case, when the defendant takes the stand, it's all about whether or not the jury believes her.
All right, so that's what she's going to try to convince the jury. So if she's able to do that, that will help her defense. But what's the worst case scenario, do you think, that could come out of her taking the stand?
The worst case scenario is if she falls apart on cross-examination. On direct examination, it's her own attorneys. I'm sure she's practiced this with them. I'm sure she knows exactly what they're going to ask her. But cross-examination is always an unknown. And what will they get into? Will they get into whether or not she really had this condition of action error? And that's something that their expert, Dr. Miller, will also testify about. Will she have slip-ups, meaning will she say things on the stand that are contradictory to what she has said before? So we have to look at what's going to happen on cross-exam.
The defense has one other witness left besides Potter. Who is it, and what can we expect to hear from that person? How will they add to this case?
It's Dr. Lawrence Miller, expert psychologist, and what he will say is something called action error, which is a human condition. It's endemic throughout society, where we tell our brains to do one thing, but our body does another. For instance, when we're in a situation driving on the highway and there's an accident ahead of us or some type of hazard, we might tell ourselves, I have to brake. But instead of hitting the brake, we hit the gas. And so this is something that is very common, but sometimes it could have catastrophic consequences. And that's what the expert will testify today.
So how is that to help her? Because when I hear it, it sounds like a fancy word for, yeah, you made a mistake, you did the wrong thing, but there's still consequences for that action. Is having an expert doctor on the stand, giving it sort of a psychological title, is that the kind of thing that can influence a jury, usually influences a jury?
Experts always have the power to give some influence on a jury because they are the only witnesses who can give an opinion. You and I, just as lay people, we can't get on the stand in front of a jury and give our opinions, but experts can. And in this case, when you said consequences, absolutely. From the prosecution standpoint, this is about accountability and consequences for your actions. But from the defense side, it's about pure accident. And really the issue is going to become, can the state prove recklessness, which means that even though it's an accident, can they prove that she had complete disregard for the safety of others?
That's interesting. So yesterday, Potter's former police chief testified, as did the defense's use of force expert. Can you explain how their testimony contradicted what the state presented earlier in the trial?
Well, what the state presented earlier in the trial through Professor Seth Stoughton is that basically Ms. Potter was reckless when she grabbed the gun instead of the taser, and that the taser was not to be used in that situation, that it was excessive force. That was completely contradicted by two things. Number one of the state's own witnesses, Major Johnson, the state called him last Friday, who said, no, Ms. Potter had to do what she did. And then the two witnesses yesterday, Mr. Iams and former police chief Gannon, who said what happened was not against law and not against policy. So we have two different sides.
So how soon, could we see the defense wrap up its case? Could we see the jury deliberating before the beginning of Christmas?
Yes, absolutely. This trial should be over today. If there's some delay, perhaps it'll go into Monday morning. But there are only two witnesses left, Dr. Miller for the defense and then the defendant herself. Now, the state has the opportunity to give what's called rebuttal evidence. If they do that and there's enough time today, it could finish. But really, we should have closing arguments in this case on Monday or Tuesday, which means the trial will be over by Christmas.
Well, it's bound to be some riveting testimony. Joe Tamburino, thanks for giving us some context so we understand what we'll be seeing later on. Thank you so much.
Thank you.